All right, perhaps we can begin now. Welcome, everyone, and thank you so much for joining us today to kickstart this four-part webinar series on legal and advocacy strategies for challenging immigration detention in the Asia-Pacific region. Recognizing the urgent need to address these challenges, the Global Strategic Litigation Council for Refugee Rights and the International Detention Coalition are organizing this series designed to strengthen the capacity of legal practitioners, NGOs, advocates across the Asia-Pacific region. The series seeks to address the systemic issue underlying immigration detention while equipping the participants with the knowledge and strategies necessary to create meaningful change. So this is a set of 4 trainings, and today's training is a comprehensive exploration of the international legal frameworks that regulate immigration detention. Our other training on the 2nd of April will cover advocacy and monitoring for immigration detention. The third training will be on strategic litigation on the 16th of April, and the fourth and final training will be on the 30th of April on alternatives to detention. My name is Nandini, and I am the South Asia Regional Litigator working with GSLC, and I'm based at Migration and Asylum Project in New Delhi, India. I will briefly introduce GSLC before handing the floor over to Hannah, my colleague from the International Detention Coalition, our co-organizers for this series. GSLC is composed of regional networks in Asia, Africa, Europe, Latin America, with around 500 members, including NGOs, refugee leaders, academics, and lawyers. As an organization, we support our members to fight back hostile policies against migrants and refugee rights being implemented across this world today. We help our members set priorities within their work for the protection of these populations, build community and share knowledge, and create, execute, and support litigation and legal advocacy strategies for our members. If you are interested in joining our council, then let us know. I will be sharing my email in the chat towards the end of this session. We are absolutely thrilled to be co-organizing this webinar series with International Detention Coalition, and it's my pleasure to welcome Hannah to introduce the organization.
Thanks, Nandini. Hi, everyone. So glad to be here and so glad to see quite a big participant list. Thanks, everyone, for making the time to come. Maybe just to say a little bit about IDC. I know some of our partners are familiar with our work, but IDC is a global network and movement that's dedicated to ending immigration detention, where we have 400 plus members across the world, including civil society organizations, community groups, and individuals. And the IDC works across national, regional, and global levels towards this goal of ending immigration detention and promoting alternatives to detention, which are community-based and upholds people's right to freedom and access to rights. In the APAC region specifically, our team works closely with governments and with our civil society partners to reform law and policy and develop ATD models that could work, especially for children that are in or at risk of immigration detention. From the legal aspect of things, we often do lots of legal analysis and support members with like legal reform, policy reform. And at the same time, we try to engage with several strategic litigation networks, including GSLC's network, to kind of promote this cross-learning around detention frameworks and how we can challenge them using strategic litigation. So hope this training is useful, and I hope everyone is able to make it not just for this one and the following as well. But I'll leave it there and pass it back to Nandini. Thanks.
Thank you so much, Hannah. So let's begin the series today with our first training on the international legal framework governing immigration detention. We have 3 speakers lined up for today: myself, my colleague Sai Shetty from Migration and Asylum Project in India, and David Mann, who is a human rights lawyer from Refugee Legal in Australia. Sai and I will be covering the international legal framework, while David will later host an intervention on the implementation of principles in litigation and advocacy, with a focus on significant updates on strategic litigation in relation to detentions in Australia. Given that we will be presenting together, I'll take the opportunity to briefly introduce Sai. She is a project coordinator at Migration and Asylum Project in New Delhi, where she works on legal representation for asylum seekers under UNHCR mandate in India, and also manages other refugee programs at MAP. She previously worked with various nonprofit organizations in India working on migration, trafficking, forced displacement, and incarceration. Thank you so much, Sai, for participating in this session. And without much delay, let's begin. I will just share my screen and
Sorry,
upload.
Nandini, could I jump in quickly? Just some housekeeping notes about confidentiality. The session is being recorded, and this will be posted later on GSLC's website, just for people who are not able to make it to be able to access. We're not really taking notes. This recording is our only form of documentation. But if there's something that you would like confidential, and understanding that the Q&A, might have sensitive materials, please just let us know. We could cut out the Q&A from the recording, or we could pause the recording as necessary. Yeah, it is really important to us that everyone feels free and safe to share their questions. So yes, we're definitely going to prioritize that. Yeah, thanks, Nandini. We can start now.
Excellent. Thank you, Hannah. All right, let me just share my screen and all right, I hope my screen is visible.
Yep, I can see it.
Perfect. All right, so I am going to start by sharing some data on migrants in detention in a few countries in the Asia Pacific region. These figures are based on statistics provided by the Global Detention Project. As we can see, there were over 30,000 detentions recorded as of 2023 in Pakistan. Of course, we know that this was followed by waves of detention of Afghan nationals in response to the deportation orders by the Pakistan government. There are reports that these detentions were often without access to legal rights for the detainees, without the detainees being able to communicate to the outside world, to their families, to their lawyers, even. These detentions were often carried out without the detainees being presented in court and or having an FIR filed against them. Unfortunately, there are no reports on the conditions of these detentions. Similarly, there's some key figures on the detentions in Hong Kong, Japan, Malaysia. Most concerning are the 150 deaths in immigration custody in Malaysia in 2022. Now, despite these concerning trends, international legal frameworks do ensure that everyone, all migrants and refugees, have the right to personal liberty. In an ideal scenario, a well-functioning, rights-based immigration system should have little to no need for immigration detention. However, there is widespread reliance on detention across the Asia-Pacific region, with states often using it as an automatic response to irregular entry or stay, often for prolonged or indefinite periods, without necessary safeguards in place to ensure that the detention is reasonable, necessary, proportionate in each individual case. Conditions of detentions are frequently poor, even constituting torture or cruel, inhuman, and degrading treatment. There is a lack of transparency on the use and condition of detention, with migrants having little recourse to challenge detention decisions. And in addition to that, there is also inadequate data collection and public reporting on immigration detention in the region. So, what are the key principles and framework governing such practice? And Sai and I will be covering that today. So this is just a brief roadmap of our presentation. We'll cover the concept of immigration detention briefly, key principles governing immigration detention, core treaties, soft law principles, how to protect vulnerable groups, a little bit on the UN Working Group on Arbitrary Detention, the regional framework, state obligations, and immigration detention in India. All right. So we are all familiar with immigration detention, which as a practice exists on a broad spectrum of restrictions on a person's liberty As we can see in the three definitions over here, IOM, UNHCR, and IDC explain the concept in relevance to the deprivation of liberty for migration-related reasons. And it can range from detainees being confined in holding centers to more formal detention facilities. And what's particularly striking about immigration detention is how it manifests differently across jurisdictions while maintaining the same core elements of the deprivation of liberty. In some countries, immigration detention centers are almost indistinguishable from prisons, while others have developed models that superficially appear more humane, but still fundamentally restrict liberty arbitrarily. Which brings us to the next question: where can immigration detention occur? A detention center is any place that functions as one where there is a deprivation of personal liberty on the basis of an individual's immigration status. So places may include not only designated immigration detention centers, but also airports, transit zones, international zones, houses, hotels, and even hostels. The common thread to all of these varied locations is what we mentioned earlier, that the detainees do not have the freedom of movement and they are not free to leave at will. Great. So the key elements of immigration detention, usually ordered by an administrative or judicial authority to restrict a person's liberty through confinement. Immigration detention is often used as a measure to control migration, as we discussed, and ensure that individuals comply with migration laws. Detention of migrants is usually for the purpose of identifying persons and determining nationalities, preventing persons from gaining unauthorized entry, and expelling or ensuring the enforcement of deportation orders. In some transit countries, migrants are also detained to prevent them from leaving the country irregularly. In other instances, asylum seekers and refugees are detained pending a decision on their asylum applications, or even despite a legal recognition as refugees in many contexts. Okay, so I'm just going to quickly explain immigration administrative detention as well as criminal detention. Immigration detention can be administrative for migration-related reasons like processing or deportation, or criminal following charges of conviction for immigration-related offenses. I'm just going to quickly give an example of the Indian Foreigners Act, which governs immigration in India. So under Section 3, the government can take administrative actions against irregular entry, exit, and stay. As discussed, it is and can, I mean, it can be and it is often packaged as an administrative measure, but yet ends up violating fundamental human rights and principles. On the other hand, there are Section 14 of the Act covers criminal law violations on overstaying visas, contravening visa rules, or violating any directions, state administrative orders under the Act. So this follows criminal procedure, and in India, often these provisions are simultaneously applied, or administrative detention often follows criminal detention. And because there's no timeline for it given, it is often indefinite and prolonged. Yeah. So in addition to this, in many contexts, detention of migrants lacks regular regulation altogether and falls into a legal vacuum, leaving migrants with little to no safeguards or remedies for any abuse suffered while in detention. Most states consider detention as an unavoidable and necessary migration management tool. And while states have the right to control their borders and determine their migration policies, questions of proportionality, necessity have become fundamental due to the prolonged detention, lack of adequate legal representation, and violations of human rights during detention. So many international bodies consider that criminalization of irregular entry is disproportionate and recommend that it be considered as an administrative infringement entirely instead. As noted on the slide, the Working Group on Arbitrary Detention has also stated that irregular migration is not in contravention to any human rights instruments. Migrants in any irregular situations have not committed any crime. So there is a global call for policy reforms given the harmful impacts of detention and a global shift towards exploring alternatives to detention, where immigration processes are managed in a way that respect the rights and freedoms of migrants. However, given the widespread use of immigration detention, and its impact, it is really essential to look at the core principles that guide the treatment of migrants and asylum seekers within any detention system. So these principles not only provide a framework for humane and rights-based migration management, but also ensure that the treatment and of individuals in detention is consistent with international human rights principles. So the first one is non-criminalization of migration. In addition to what I just mentioned earlier on the benefits of considering irregular movement as an administrative infringement, criminalization also often increases stigma in the community and reduces access to services while also straining and often already overburdened systems. So governments would also benefit from non-criminalization. The second most important principle is that detention must be considered as a measure of last resort. This principle states that deprivation of liberty should be an exceptional measure after all other less restrictive measures have been considered and found inadequate, as individuals' liberty and alternative to detentions should always be considered first. Moreover, these decisions must be based on individual assessments of cases, not a mandatory rule that is applicable to a broad category of persons. The third principle is of proportionality and necessity. Immigration detention should only be used in cases where an individual assessment confirms in that case of a particular migrant that there is an existence of an acceptable basis for which immigration detention may be justified. It follows that detention should not be used as a means of a deterrence or punishment, because that in itself is not one of the very limited acceptable grounds that justify detention. Individual assessment of the existence of risks can determine whether detention is considered necessary, reasonable, or proportionate after non-judicial measures are first considered. Lastly, the conditions of detentions must be humane and uphold the dignity of the individual. No migrant, regardless of their legal status, should endure conditions that are degrading, inhumane, or that violate their fundamental human rights. They must provide adequate and detention centers must provide adequate accommodation, sanitary living conditions, access to good health. They must protect the privacy of individuals. Detaining authorities must ensure personal safety and provide for their needs, both physical and psychological, especially for vulnerable persons. This can include access to medical care, and they must also be protected against all forms of abuse, exploitation, and violence that can occur in a detention center. Moreover, migrants should be able to move around freely within the place of detention. Family members should be accommodated together if possible, and migrants, most importantly, should be able to maintain contact with the outside world. To facilitate these conditions, it is also important that irregular migrants be segregated from persons detained for criminal offenses. The next is the principle of non-refoulement. Governments must respect this principle and prevent returning individuals to a country where they face a real risk of persecution, torture, grave human rights abuses, and other irreparable harm. Lastly, the right to due process and legal remedies. That procedural safeguards must be ensured for all detained persons, and detained persons must be informed of the reason for detention in a language that they understand, informed of their rights, and this decision, most importantly, must be made by an authorized body in accordance to a well-defined legal criteria with the right to appeal such a decision, removing any doubts of arbitrariness. And as I mentioned earlier, the detainee must be able to communicate to the outside world, particularly lawyers, to be able to access effective legal aid. Now, these principles essentially inform the state of its legal obligations to protect the rights of individuals in detention, including their obligation to consider alternatives. Now, given that migrants are at an increased risk of human rights violations in detention, a heightened duty of care is imposed on the authorities to protect their rights and prevent, investigate, prosecute, and even punish all rights that are violated um, during detention. Okay, so having explored the key principles that should guide immigration detention, it is important to recognize that these principles are not just theoretical, they are grounded in well-established international treaties and conventions. So we will quickly look at a few core instruments that support and uphold these principles. The first one is the International Covenant on Civil and Political Rights. It is one of the most important legal frameworks governing detention practices across international borders. At its core, it provides critical protection for individuals in detention through the noted provisions on the slides. Article 7 prohibits torture, cruel, inhuman, and degrading treatment. This is an absolute provision that applies in all contexts, with no exceptions permitted in any situation, even during emergencies. Article 9 specifically addresses arbitrary detention and mandates that detention must be carried out in accordance with procedures established by law, with safeguards to verify its legality. Moreover, it also covers legal guarantees that we discussed earlier. Article 10 affirms that all persons deprived of liberty must be treated with humanity and respect for their inherent dignity. Again, the provision requires the states to maintain detention conditions that meet basic human rights standards. In addition to this, the Human Rights Committee, which reviews state compliance for the ICCPR, has released key guidelines focusing on the issue in its General Comment 35. I'll quickly note some key points noted by the committee. First, the committee has clarified that while immigration detention is not prohibited, it is under exceptional circumstances that it must be relied upon. And when it is, it must be reasonable, necessary, and proportionate in each individual case. The committee has further highlighted that states must first look into account less invasive means of achieving the same ends as immigration detention and considering non-custodial measures and alternatives to detention. Any necessary detention should take place in appropriate sanitary, non-punitive facilities and should not take place in prisons. They've also imposed a heightened duty of care to take any necessary measures to protect the lives of individuals deprived of their liberty by the state. So, by arresting, detaining, and depriving individuals of their liberty, state parties assume the responsibility to take care of their lives and bodily integrity, and they cannot rely on any lack of resources or other logistical reasons to reduce this responsibility imposed on them. Lastly, the committee has noted that detention must be subjected to periodic re-evaluation and judicial review. These are strong safeguards against indefinite detention. Further, the committee has also cautioned that the inability of a state to carry out deportations or expulsions of people because of statelessness or any other obstacle, they do not justify indefinite detention. However, despite the widespread ratification of ICCPR, implementation challenges persist, as we all know, and many states maintain reservations to key provisions, and others face capacity constraints in meeting obligations. Okay, so next we'll discuss the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. Again, I've noted the relevant provisions in the slide. Article 1 of the Convention defines torture in terms that clearly encompasses acts in immigration detention contexts when they involve severe suffering inflicted by officials. Article 3 enshrines the principle of non-refoulement, especially relevant for asylum seekers, as we discussed before. Article 10 mandates that states provide proper training to all officials involved in detention, including immigration officers. So this training must emphasize on the absolute prohibition of torture, ensuring that those who interact with detainees understand this legal obligation. Article 11 requires systematic review of detention practices, including in immigration facilities, to monitor and improve detention conditions and prevent torture and ill treatment. Article 16 further extends cats' protections by prohibiting cruel, inhuman, and degrading treatment that may not rise up to the level of torture. And the United Nations Committee Against Torture, which monitors the implementation of this convention, has read this article to include conditions in detention centers like overcrowding, inadequate medical care, or even prolonged detention to constitute as violations under this convention. They have also included prolonged isolation to this, hence setting out international law standards with respect to solitary confinement in detention. And like the ICCPR, the committee has also held that immigration detention should be exceptional, not routine. I will next discuss the Refugee Convention because several thousand refugees and asylum seekers are currently detained throughout the world, despite the fact that they face severe threats of grave human rights abuses in their home countries. Often, detention is seen to be as a necessary response to actual or perceived abuses of asylum processes or responses to threats to the security of a state and welfare of a community. But in reality, detention often deprives asylum seekers of an opportunity to present their claims for asylum. This is especially likely when asylum seekers are held in remote locations or do not have communication with the outside world and are detained arbitrarily without judicial review. The Refugee Convention, together with UNHCR guidelines on detention, which I'll just be speaking about, establish critical protections for asylum seekers and refugees against arbitrary detention. The principle of non-refoulement is enshrined in Article 33, creating an absolute prohibition that applies regardless of a person's detention status and ideally should supersede domestic immigration enforcement priorities. Now, Article 31 of the Refugee Convention explicitly provides crucial protection against penalization of illegal entry or presence of asylum seekers and refugees. So, this provision recognizes the reality that refugees cannot comply to normal immigration procedures while fleeing persecution. It prohibits states from imposing penalties on refugees who enter or stay irregularly, provided that they submit themselves or present themselves to authorities without delay, authorities assessing their asylum status. This article directly challenges the practice of routine detention of asylum seekers, establishing that seeking asylum is in fact not a criminal act. For the Article 26, particularly when read alongside Article 31, again establishes that detention of asylum seekers should be exceptional. Now, when can detention be relied on in such cases? The UNHCR's Executive Committee has noted that if necessary, detention may be resorted to only on the grounds prescribed by law to verify identity, to deal with cases where refugees or asylum seekers have destroyed their travel or identity documents, or have used fraudulent documents in order to mislead authorities of the state in which they intend to claim asylum, or protect national security and public order. Further, the Executive Committee has also stated that detention measures taken in respect of refugees and asylum seekers should be subject to regular judicial and administrative review. Now, the linkage of deprivation of liberty of asylum seekers and an identifiable and lawful objective to detain them keeps this practice under the larger umbrella of rule of law and protecting rights of asylum seekers and refugees. And of course, the Executive Committee, of course, also urges states to explore more actively all feasible alternatives to detention. I'll quickly be brushing through the UNHCR detention guidelines because we have covered most of the principles till now, and other principles will be covered by my colleague after this. Okay, so now the provisions that I mentioned earlier should be read with these guidelines on detention to ensure that the treatment of asylum seekers is in line with international standards in a way that prioritizes the rights and dignity of those seeking asylum. These guidelines solidify the principle that asylum seekers should not be detained. They further provide that detention may be resorted to only for specific exceptional reasons that were noted earlier. The guidelines also emphasize on the importance of considering alternatives to detention. And if detention is unavoidable, asylum seekers should be entitled to certain procedural safeguards that we have also discussed in terms of being informed of the reason for detention, an opportunity to appeal, and the ability to review um, detention decisions. It also provides for independent oversight and monitoring of detention and the conditions in detention. Uh, the guidelines place special emphasis on the protection of vulnerable persons, including children, women, victims of survivors of torture and trafficking, and stipulate that they should not be detained. And if detained, then their specific needs should be met. Lastly, these guidelines outline standards for the conditions of detention that we have discussed before, emphasizing on the need for safe, humane, and dignified conditions. All right. So I'm going to hand over the floor to my colleague Sai, who will take you through other soft law principles and regional frameworks and so on.
Thank you, Nandini. Can we move to the next slide? Nandini's covered core treaties and conventions. I will be covering the basic minimum standards that need to be maintained while somebody is in detention. I will also be talking briefly about minimum conditions in prisons because very often there could be instances where refugees and asylum seekers are punished for violating um, visa rules or laws pertaining to entry, exit, overstaying visas, and could also be undergoing criminal punishments, including imprisonment. So diving directly into the Mandela rules. Mandela rules earlier were the standard minimum rules for treatment of prisoners, which were first adopted in 1955. In about 2011, there was a review process that started, and since 2015, the revisions were approved, which then are known as Mandela rules or the United Nations Standard Minimum Rules for Treatment of Prisoners. While the earlier principles were focusing on essentially discrimination on the basis of race, color, sex, language, religion, etc., Mandela rules shifted the focus to dignified life, valuing prisoners as human beings. And if you see, the language kind of focuses more on providing a dignified life for anybody who's in a prison or a correctional institution. I'm not going through all of the rules, but I'll quickly go through what is relevant when it comes to foreigners, refugees, asylum seekers being in prison. The most important being having access to lawyers or legal aid, being able to speak to people outside of the prison, could be their families, could be lawyers outside. Another thing that becomes important when it comes to immigration detention or detention of foreign nationals is consular access. So Rule 62 speaks of having access to the embassy or the High Commission of the country, having access to diplomats and individuals within the council. What is also important is that prisoners are kept informed about the world outside and have access to some of these things, including newspapers, books, periodicals, etc. Um, Another important thing that is established by these rules is an oversight mechanism, which applies to situations of detention where even foreigners have been detained. And these rules talk about two kinds of internal inspections and external inspections, which can include the government itself doing inspections, and also having committees, which includes activists, civil society, being able to access places where foreigners are detained, and doing inspections, submitting reports on the conditions prevalent in these institutions. Next slide. Nandini, yeah, thank you. Okay, then I move to the UN Body of Principles for Protection of All Persons under any form of detention or imprisonment. While this is a little older than the Mandela Rules, this document distinguishes between a detained person and an imprisoned person. Detention being when a person is deprived of personal liberty except as a result of conviction for an offense. So anything that we're talking about under immigration detention would essentially get covered here. When it comes to the core principles under this, we go back to similar things like treatment with dignity and respect for human rights, court-ordered detention and effective judicial review, access to a lawyer, legal assistance, information that right to information in understandable language. That's also actually the case in the Mandela Rules. And then what is important is notification of reasons for detention, and kind of fairly similar to what we've seen under the Mandela Rules. Can we move to the next slide? Okay. I'm going to briefly go through some groups that are vulnerable and might require, say, some additional focus on detention of these groups. Starting with children, and I think across various documents, the one thing that stands out is looking into the best interest of a child, and detention is really not ever seen as best interest. There are various committees, including ICCPR, UNCRC, that have commented on children not being detained at all, unless it is a measure of last resort. And while in detention, what is important is that children are reunited with their families, are able to have access to their parents, siblings, etc., etc. When it comes to specifically asylum seekers and refugees and migrant children, there is a need to ensure that they are with their families. Children are not detained. Legislations need to be appropriately amended so that there are alternatives, especially for children, as opposed to putting them in regular detention centers. And having said that, there needs to be safe and dignified accommodation as well as support services, which could include legal aid, it could include mental health support, it could include provisions for them to access education, etc. That needs to be available. When it comes to women, again, I think a lot of these groups that I discussed could be women prisoners or detainees, or I will be discussing elderly prisoners, people from the LGBTQI community, etc. The core principle here when it comes to detaining any of these groups is the principle of non-discrimination. And that's just something that flows in various documents that address detention of all of these groups. The CEDAW general recommendations that are here on the slide, while they cover the general treatment of women who are seeking asylum or refugees, or even through resettlement procedures, they do talk about detention of women specifically. And when it comes to detention or irregular migration, it recommends that state parties should ensure that border police and immigration officials are adequately trained, supervised, and monitored for gender sensitivity and non-discriminatory practices when dealing with women, refugees, and asylum seekers. Further, it also focuses or sheds some light on the fact that women who are on the move could especially be victims of trafficking. And this needs to be taken into consideration when considering detention in such cases. When it comes to detention, it requires for there to be respectful treatment of detained women and asylum seekers, including access to the appropriate forums where their refugee claims will be decided. Could be UNHCR, or that could be a national asylum system. The Bangkok rules, or what is called as the UN rules for the treatment of women prisoners and non-custodial measures for women offenders, have about 70 rules, again focusing on gender sensitivity, non-discrimination being the core principle throughout these documents. Yeah, and yeah, final point being when it comes to the condition of detention centers or prisons, protection from gender-based violence. We can move to the next one. Okay, again, if you see on these slides, there is the protection against discrimination, which is the core principle when it comes to persons with disabilities. There also need to be accommodations that accommodate whatever disability they have. So that's an additional requirement to be taken care of in detention centers. When it comes to trauma survivors, like children over here, again, it should only happen in exceptional circumstances. While Nandini covered a bit of this when she spoke about CAT, what is essential is to have safeguards, procedural safeguards for torture survivors to be able to access various offices or remedies. What these principles also talk about is prevention of re-traumatization, with the understanding that detention can re-traumatize survivors of torture. There's also a requirement for states to implement screening mechanisms to identify torture survivors early in the immigration process. And only if detention is unavoidable should somebody be detained. Further, there should also be options of collection of evidence that could be important when it comes to cases of torture. We can move to the next. Okay. Again, principle of non-discrimination kind of stands out across all of these groups. Beyond that, what is important is that there is, when it comes to LGBTQI individuals, protection of privacy and appropriate placement, individual assessments, vulnerability screenings, equal access to various services. When it comes to elderly prisoners, there are UN guidelines that speak extensively about the treatment of elderly asylum seekers in detention. And again, detention over here should be seen as the last resort option. When it comes to refugees and asylum seekers, one needs to understand that there could be situations of smuggling or trafficking. A lot of it gets covered under the various protocols that are in place. Again, prevention and protection not admitted as a ground for detention. That's a core principle. In reality, there are various instances where people who have been trafficked are seen as irregular migrants and end up in detention, not just administrative detention, but often also penalized and in criminal detention. We can move to the next one. Okay. I'll quickly come to the UN Working Group on Arbitrary Detention. The mandate of the working group centers on investigating cases of deprivation of liberty that are deemed arbitrary. Nandini, in the beginning, has covered the definition as per the working group on arbitrary detention, meaning that whenever there is a contravention of international human rights standards is when the working group kind of acts. They investigate situations of arbitrary detention where there is no legal basis for detention. Detention results from exercising fundamental rights and freedoms. For example, say someone protesting against the government. there's a serious violation of right to a fair trial. And what is important for our discussion today, when asylum seekers, immigrants, or refugees are detained under administrative decisions without the possibility of judicial review. And a lot of countries have laws or procedures. A lot of countries in the region actually have laws and procedures where administrative detention does not have a possibility of judicial review. Administrative detention becomes indefinite, as Nandini is already covered, because there are no limits for the removal proceedings once someone is put into administrative detention. How can one get in touch with the working group? There are various ways to communicate, including by making submissions to them, requesting they themselves can make urgent appeals to different countries if, say, arbitrary detention in a country is brought to their notice. The working group also conducts country visits. They issue opinions on uh, uh, broader issues around arbitrary detention, or on specific cases of detention where they see an element of arbitrariness in the detention. The working group also develops thematic reports on specific issues related to arbitrary detention, such as detention of migrants, asylum seekers, that are relevant for our discussion today. They are also responsible for promoting international standards, making sure that the standards that we just discussed through this presentation sort of are implemented, are included in various, say, detention manuals of countries or prison manuals of different countries. They are also responsible for clarifying what constitutes arbitrary detention. And as I covered just right before this, when there is no legal basis, when detention is for exercising human rights, when there are violations of fair trial, when administrative detention is prolonged and without judicial review, and if detention is based on discriminatory grounds, all of these fall under arbitrary detention. I think we can move on. Okay. Quickly going through some regional instruments. There is the Asia Pacific Forum of National Human Rights Institutions. APF is essentially a regional network of human rights institutions in the Asia Pacific region. It supports its members. A lot of the participants come from member countries over here in promoting and protecting human rights. And it works to ensure that national human rights institutions comply with various international standards. Essentially, it is a place where national level human rights organizations can network and gain support. The Bangkok rules I briefly discussed when I spoke about treatment of women prisoners, essentially focusing on specific needs of women prisoners, gender-sensitive approach in prison systems, addressing issues like healthcare, safety, rehabilitation, etc. when it comes to treatment of women prisoners. The Bali process on people smuggling, trafficking, and related transnational crime is a regional forum that brings together about 45 countries and international organizations to address challenges of people smuggling and trafficking in persons. It is non-binding. It is sort of a forum for cooperation. It focuses on key regional issues and information sharing capacity building to combat issues around trafficking and smuggling. And then there is the ASEAN Declaration on Rights of Child in the context of migration and the Convention on Trafficking in Persons. Yeah, I think we can move on to the next slide. I am not going to repeat this because we fairly covered what the standard minimum principles are, where human and dignified detention conditions are important. Access to legal representation becomes important, access to healthcare, mental health support, protection from harm, communication with the outside world, including family legal aid, embassy. Then independent monitoring is another minimum detention standard or a core principle when it comes to detention. Unfortunately, a lot of countries, when it comes to immigration detention, do not have independent monitoring systems, while they might have some sort of systems for monitoring of prisons. Immigration detention is something that is very often overlooked when it comes to monitoring the conditions of detention. We can move to the next one. State obligations essentially derive from everything that we've discussed till now, so I am not going to go into this. I would just want to stress on the principle of non-refoulement. And I mean, speaking about it in the context that a lot of immigration laws have what is called removal or deportation proceedings, which can be violative of the principle of non-refoulement, affecting refugees, asylum seekers, and essentially the groups that we all work with. We can move to the next slide. I am going to end with a little bit about immigration detention in India and what our experiences have been. Nandini briefly spoke of the Foreigners Act, but India does have a system of administrative detention and criminal imprisonment. Administrative detention is by officers of the immigration department if they want to restrict someone's movement, entry, exit in a country, people can be detained. A lot of refugees and asylum seekers end up in administrative detention this way. On the other hand, there could also be criminal imprisonment for violating their visa rules, for forging documents, etc. There are too many instances where both these are applied together, where some proceedings happen as per the established criminal law, while administrative detention follows the completion of the criminal imprisonment. Administrative procedures essentially would look at removal of a person from the country. And India does not have a very transparent system of what these proceedings look like, nor are there any limits to how long these proceedings should take. And some point, and I come back to the same point that we've been talking about. This is why then administrative detention becomes arbitrary and indefinite. India very recently did put together a model detention center manual. Unfortunately, it is not as detailed as it should have ideally been. It does not have clear guidelines about what oversight mechanisms would be. It does not speak in detail about access to the outside world, legal aid, communication with family or with lawyers or with the embassies or any kind of support structures. India is also in the process of drafting a new immigration and foreigners bill. This was very recently tabled in the parliament. It essentially puts together various acts that we've had, including the Foreigners Act. There's also a Passports Act. And it criminalizes irregular migration, which goes against the international principles that we've been speaking of since the beginning of this presentation. I am going to quickly talk about Raju Baladas versus Union of India, where it wasn't necessarily a refugee, but an irregular immigrant identified or the government claimed was a Bangladeshi national. And he was in detention. His wife filed a petition. And this is a very recent judgment where the Supreme Court took cognizance of the poor conditions of detention centers and asked the government to look into instituting proper sanitation systems, improving the quality of food, medical health, access to medical support available to people in detention, and also criticize the quality of water available, etc., etc. And went to the extent of asking for the release of people detained if the conditions can't be improved. We can move to the next one. This is probably the last slide. I think when it comes to detention of asylum seekers and refugees, there can be additional vulnerabilities when they are detained, including them being exposed to assault, sexual abuse, torture, ill health, lack of counseling support, limited legal assistance, etc., while they are in detention. Detention conditions in India have also been discussed by courts, be it high courts or Supreme Courts, where they've looked into the unhygienic conditions, arbitrary or indefinite detention, lack of access to healthcare, lack of legal rights, etc. And Sabira Khatun is another case. There are a few cases of Rohingya detention that have reached the high courts and Supreme Courts. This one being one of those where her sister was detained in a detention center arbitrarily, indefinitely, and lacked access to mental health services. And this is something that the court stressed on for her to have access to a lot of these services. It also looked into the lack of an oversight mechanism right now in place in India, which is very much in need when it comes to immigration detention. Yeah. What happens when refugees and asylum seekers are in detention, and this is also from our experiences in India, is that they do not have access to UNHCR, especially in some parts of India, where UN is not allowed to function from, as like the the northeastern parts of India. People in immigration detention lack complete access to UNHCR to register with UNHCR as asylum seekers, and then lack access to any kind of legal remedy. I think that's it. Thank you.
All right. Okay, thank you so much, Sai. We hope this helped you understand the legal underpinnings that should ideally shape policies and practices in this area, as it sets out the foundation for how we approach the issue on a global, regional, as well as a national level. Now, to continue our discussion, we will shift focus to the practical side of things, the implementation of this framework. Or it's one thing to have a robust legal framework, but how do we ensure it's effectively applied? Is it effectively applied? We are thrilled to have David Mann from Refugee Legal Australia here to shed light on this issue. David is a human rights lawyer and the CEO of Refugee Legal. He has worked in various capacities assisting refugees and asylum seekers for over 20 years. Since 2001, he has led refugee legal teams in successfully arguing 12 out of 12 landmark High Court challenges. David previously sat on the board of the Refugee Council of Australia and the Victorian Foundation for Survivors of Torture Ethics Committee. He currently sits on the Peter McMillan Centre on Statelessness Advisory Board and on a range of peak government consultative and advisory bodies. He has been appointed as the UN High Commissioner for Refugees Advisory Board of Eminent Persons and is regularly invited to present at the High Commissioner's Dialogue on Protection Challenges. David has also been a recipient of numerous prestigious awards and is frequently named as Australia's leading immigration lawyers in the Australian edition of Best Lawyers. We are really excited to have you, David. Over to you.
Well, thanks so much. It's a real privilege to have been invited to present, and greetings from Australia, from Melbourne. Look, I want to start with a story, and it's a story that dates back about a decade. we had a case before the apex court in Australia, the High Court of Australia. And part of our test case, part of it was a challenge to the indefinite detention of a convention refugee in Australia. And our lead counsel, one of the finest in Australia, submitted to the full bench of the High Court. He said this, he said, "Your Honours, in relation to the plaintiff's right to liberty," and all 7 judges leant forward, perplexed, mystified. The Chief Justice then asked counsel, "What precisely are you referring to?" Counsel quickly corrected himself, realising that he just made a legal faux pas of the highest order. "I withdraw that, Your Honours," he said. The reality is there is no right to liberty under Australian law. Australia has a profound problem with the right to liberty for asylum seekers and refugees and other non-citizens. Indefinite detention, often prolonged and sometimes for more than a decade and without charge, has been the long-standing law and practice. But there has been a major development recently through successful strategic litigation. In fact, 2 major developments, I would say, which are related. And that's really what I want to address in this presentation, is the developments. The first occurred in November 2023, so just over a year ago, really, about a year and a half ago now. The High Court of Australia ruled that indefinite detention is unlawful and unconstitutional. That is, if a person cannot, in fact, be deported in the foreseeable future. This was the accepted fact for the man who brought the case, a stateless Rohingya refugee who'd been convicted of serious offences in Australia. The limiting principle in the judgment of the High Court was this. The limiting principle is the ability of the government to deport in the foreseeable future. That is, indefinite immigration detention is unconstitutional and unlawful where there is said to be no real prospect of removal from Australia becoming practicable in the reasonably foreseeable future. That is, if someone's stuck and can't be removed. In this sense, the detention can no longer be seen as legitimately connected to an immigration purpose, which is removal from Australia. It's not connected. It can't be seen as being, because it can't be affected. As such, the detention in law, the High Court said, becomes punitive and therefore cannot be imposed by the government. That is because under Australian law, it is clear, and under the Constitution, it is clear that only the courts, not the government, can impose punishment. As a result of the case, more than 200 people have so far been freed from detention, but around 1,000 people remain detained. Why is that the case? That is because the ruling does not apply as transformative and fundamental landmark case, a watershed really. But as that said, the ruling still does not apply to people pursuing asylum claims or other legal proceedings for residency. It only applies when someone can't be removed. The case is called NZYQ. So we have acronyms to anonymise in Australia for cases in this area. So it's NZYQ. It overturns a 20-year-old precedent in the case of Al-Kateb that ruled that indefinite detention was lawful, which enabled successive governments to detain many thousands of people for years with no end in sight, and possibly forever. But the recent High Court ruling was not based on fundamental human rights. It was not based on international legal frameworks that seek to regulate immigration detention, despite Australia being signatory to relevant international treaties which limit detention. Put simply, it was not based on the right to liberty. It was based on constitutional interpretation. This is because Australia does not have constitutionally enshrined a constitutionally enshrined Charter of Rights or Bill of Rights. Now, some quick but critical context is necessary to be aware of Australia's legal setup, which is distinctive and somewhat unique for a constitutional democracy. Notoriously, there is a scarcity of express human rights in the Constitution and no express or enshrined right to liberty. There is also no express or enshrined right to asylum, just to be clear. This means that litigation opportunities have been limited because of this system, and we have had to look as litigators to look for opportunities within it. It's not that the courts have been unresponsive, but that they have had to work within these constraints themselves, of course. And litigation has involved a fair degree of legal ingenuity and innovation. Despite the fragility of human rights protections in this context, Australian lawyers have been able to achieve some significant constraints on executive overreach. Yes, the lack of constitutional fortification means that those constraints remain highly vulnerable to political and policy change. They do not have constitutional foundations and they lack constitutional fortification, if you like. But as we see in the political and policy terrain, a deepening a sense of systematic rights violations and harm, the importance of the rule of law and strategic uses of the law become ever greater and their protective potential very real. In this context, as fundamentally important as the NZYQ ruling is, it's created, of course, a wealth of uncertainty about the scope of the government's power to detain. And this underscores the powerful potential as well as real complexities when we don't have that constitutional charter of rights, when we don't have international legal frameworks implemented in Australia. One case since, for example, has sought to test the, if you like, the parameters of the NZYQ ruling with a recent ruling on the limits of indefinite detention whether they apply where a person refuses to cooperate with their own deportation, where that non-cooperation itself makes deportation essentially impossible. Deportation essentially impossible. So in other words, the case involved a failed Iranian asylum seeker who still feared return. The High Court found in his appeal that where the detention remains lawful, I'll just start again. The High Court found that where the indefinite detention continues, it is lawful where it is said to be affected by the non-cooperation itself. In other words, if someone refuses to cooperate with their own removal, and that non-cooperation itself is essentially the core cause of not being able to deport the person, detention remains lawful. Indefinite detention remains lawful. So that's a limitation on the NZYQ ruling itself. But the question arises, how did it take 20 years to successfully challenge indefinite detention? And I think there are some important lessons in this for all of us in terms of strategic litigation more generally. There was sustained strategic litigation by my organisation, Refugee Legal, and others, and we developed the same arguments and presented the same arguments to the High Court, differently constituted, which ultimately prevailed in the recent case of NZYQ. So exactly the same arguments were made time and time again, but we struck a number of barriers in the previous 20 years. 4 key barriers. Firstly, governments engaging what I would describe as strategic counter-litigation, seeking to circumvent challenges through capitulating, caving in before a court ruling, and releasing people from detention before that ruling to avoid defeat, which could set a new precedent, limiting or ending the power to indefinitely detain. So that's one. Secondly, unsuitable factual scenarios to test the question. Third, at different times with different judges, a divided court on the question. And fourth, a related reluctance, I think, from some courts differently constituted to confront the constitutional question. So in other words, to provide a favourable ruling, but by resorting to resolving the case on more technical or limited statutory grounds, which did not then provide for a fundamental precedent. NZYQ then is a powerful story of the critical nature of sustained litigation in the face of substantial obstacles, setbacks, and challenges. But it's also a story of future challenges, legal, policy, and political and public. And I think the response to the ruling, it's important to emphasise, has been a maelstrom. The government has rushed through legislation twice to circumvent the High Court's ruling and to subvert obligations under law not to deport people to persecution. I'll give you some examples. Since the ruling, they've legislated a blanket imposition of ankle bracelet monitors and daily curfews of 8 hours on people released in accordance with the ruling. We have challenged that, and I'll come to that in a minute. We've successfully challenged that. Secondly, they've introduced new laws of preventative detention to allow redetention of people judged to pose a high risk of committing serious violent or sexual crimes. Third, proposed their laws to force asylum seekers, the government says itself, have genuine fears, to assist with their own return to possible persecution. Now, I want to come to the second case briefly, which followed on from NZYQ, and that was a challenge that we brought last year with judgment in the High Court last year in the case of YBFZ. YBFZ involved a client of ours, essentially a stateless man who arrived in Australia as a refugee from Eritrea when he was 14. His refugee visa was subsequently cancelled, and he was taken into immigration detention where he remained for over 5 years. That was cancelled due to offences that he'd committed. He was one of the people released from indefinite detention in accordance with the NZYQ ruling. He had an ankle bracelet monitor imposed on him, as well as that he had a daily curfew. We brought a challenge in the High Court in relation to those conditions, the ankle bracelet and curfew, on the basis that they were both forms of deprivations of liberty that constituted punishments and therefore could not be imposed by executive government under our constitution. The High Court ruled in his favour in November last year, and as a consequence, in over 100 people, at least 100 people, benefited directly from that ruling, where the High Court found that, and it was an incredibly important ruling, that the ankle bracelet monitoring curfew conditions were unlawful. A victory for really, I would say, fundamental freedoms and the rule of law in Australia, because it underscored a bedrock principle that for everyone, whether citizens or non-citizens, the government does not have the power to punish people by stripping them of their fundamental rights and freedoms. That, if you like, everyone, that is citizens and non-citizens, should have the same protections and freedoms under law. The court ruled that our client's liberty cannot be deprived, and with those conditions, as they impose, that they effectively constitute punishment, which cannot be imposed by the government, because it's only the courts, not the government, under our constitution, that can impose punishments. They also described the punishment as a form of extrajudicial collective punishment, and that fundamental protections against arbitrary interference with liberty and bodily integrity apply equally to citizens and non-citizens. I think it's incredibly important to emphasise that in the context of what I was referring to before, and that is Australia does not implement international legal frameworks on detention, and yet the High Court has found a different interpretation, which is really consistent with those international principles that we would understand through our constitution and through the common law. I want to just finish with two simple points. The first is the backlash once again, or the response of the government to this. And what the government have done is rush through further legislation, which has sought to reimpose the conditions, the ankle bracelet and curfew conditions, on some people, nonetheless with a far more stringent test, which can be appealed under judicial supervision. Number two is it has expanded its powers now to deport people who released in accordance with the indefinite detention ruling, to deport people to third countries. And the country at the moment that they've reopened an agreement with is Nauru. So in other words, people that they have to release from indefinite detention that couldn't be removed, they've now entered into an agreement with Nauru to deport those people, as many people as they can, to Nauru. Another law that they've legislated now is to reopen the findings, protection findings, that is Convention findings in relation to refugee or complementary protection, to reopen findings and to potentially to overturn that finding, to open the gate to deportation of people that they couldn't deport because of that protection finding. And so there's some of the examples of legislation that has been rushed through Parliament, again in response to the High Court ruling. I want to finish with a couple of observations about this litigation and more generally where the principle where detention, the laws of detention and indefinite detention stand in Australia. I think the first point is that amidst these ongoing tensions and tussles, the role of strategic litigation is fundamental. And it's fundamental to advance people's rights and lives under the rule of law. Many people have had their rights protected far more strongly through this strategic litigation, despite the responses of government. This work has also been underpinned by critical collaboration of legal NGOs, pro bono law firms, pro bono barristers over the years. And the combined expertise, resources, and deep commitment of these partnerships is instrumental in ensuring that we can advance these protections and bring these cases. On the YBFZ case and the NZYQ case, and particularly the YBFZ case, I also want to just suggest something to be investigated for the future, certainly for those involved in litigation in Australia. And that is that while not expressed in the judgment, there is now a real question with that judgment about whether it might have started to move further toward creating an implied freedom under the Constitution, an implied freedom, the right to liberty under the Constitution. That's a question for the future. But what has happened with both cases is that it certainly has advanced protections in relation to liberty, even though we don't have an express right to liberty. Finally, this is all, I think, a stark reminder that courts don't go in search of cases. They must be brought by us. Thank you.
Thanks so much, David. I think that was a really helpful way to ground some of the previous presentations in like a concrete example as well. I'm going to jump into Q&A, just a little bit mindful of time as well. Understand that some people might have to drop off, but if you're able to stay another 5-10 minutes with us, that would be great. Maybe, David, I'll ask the first question, just because you have just mentioned that kind of the importance of collaboration and the amazing kind of pro bono work that was happening with legal NGOs and other law firms in Australia. Someone has asked, how can we promote that culture of pro bono and creative legal solutions among the legal fraternity in Malaysia? So maybe I'll pass that to you first.
To me?
Yes.
Yeah. I mean, I not knowing the terrain in Malaysia very well, I mean, there are limits to my response, of course, but I think that one experience that we've had is that we've now got 27 pro bono law firms working with us, partnering with us on a range of different programs, so partnering at the same time in the same programs. And not all of them are litigation. In fact, most of those programs are not litigation, but some of them are or do involve litigation. And I think that what I would say part of it is that there is a deep reservoir of goodwill amongst pro bono law firms, corporate law firms, that I think remains to some degree untapped. I think that there is huge potential in partnering with pro bono law firms. I think that there are, I mean, I'm happy to be in contact, by the way, with anyone that's interested in how we've developed ours, but our program has been transformative because hundreds of pro bono lawyers work closely with us, but the partnerships have developed very well over the years through, I think, an equivalence of standards, an equivalence of belief in, I think, fundamental, convictions about the rule of law, but also really good systems in place and well resourced on our end in terms of making sure that we are able to work very closely with pro bono law firms and pro bono counsel to resource them, to supervise, to oversee. But they're true collaborations in the sense of a meeting of minds. They're a meeting of sharing of resources, and they work. And I think that, so conceptually, the foundation of it is that no matter who's the background of the person that we're helping, no matter who they are, where they're from, that they should be on equal footing before the law. And the only way to do that, as we all know, is to come with the same, if not better, calibre of legal team as well resourced as the government. So that's the concept behind it. But that requires getting, you know, obviously partnering with excellent law firms and you know, those within them that are really committed, but also I think excellent leading legal counsel.
Thanks, David. Okay, we've got a question that's specific on India, so maybe I'll pass this to Nandini or Sai. It's from Samundara, and Samundara asked in the chat a while ago, does UNHCR have access to Kashmir area to monitor the situation of refugees and asylum seeker detainees?
You can take that. Thank you for that question. UNHCR unfortunately does not have registration access in Kashmir or in Northeast, any place that the Indian government declares disturbed. UNHCR does not have access. Having said that, I know that sometime late last year, UNHCR did send a team to look into some atrocities against Rohingyas in Kashmir, where I think some people from the protection team did visit Rohingya camps in the region after there were some detentions, and there were measures like water cuts and electricity cuts at Rohingya camps in Jammu. So that has happened.
Thanks, Sai. I think Sriya had a question about protection measures for women prisoners and detainees. Maybe I'll take a shot at answering this, and then one of the panelists can jump in as well. I think Sai did mention the UN Bangkok rules, and that's kind of the only protection measure that there is on gender-specific provisions. But that is often applied only to the criminal justice system, and we've seen very inconsistent application with regards to immigration detention. But at the same time, I don't believe that there is a concerted effort to develop similar guidelines for immigration detention, because as Nandini said, and as I said in their presentations, what we actually need is that, like, any form of detention and deprivation of liberty is a harm to women's rights and the rights of girls. So what we're actually asking is for them to be released from detention into community placement, and where they're able to access their rights in a full and free way. Does anybody else have an add-on to that? Cool. We've got a couple more questions. Samundra had a really big question. Maybe I kind of open it up to all of you to give some input. It's around the Trump administration coming into power and setting a precedence on sending migration to El Salvador, despite the judgment from the court, and how world action will shift now. So quite an interpretive question. David, maybe linked a little bit to, you know, what the Australian government is doing with Nauru as well. Probably not a clear answer, but I'll open the floor to any of the panelists if they'd like to share some thoughts.
I'm happy to kick off if, yeah.
Go for it.
I think it's very dangerous what's happening, because it's not, as we all know, I mean, it's sort of obvious, but it's not a new phenomenon what's happening. Externalisation policies have been pursued by a number of governments. I mean, Australia has been one of the leading proponents, and not just proponents, but actually has been one of the leading actors in externalisation policies, which, you know, as we know, are about offshoring. They're about denying people access to territory, and either initially or once they're in the country, deporting without due process. And And one of the features that we've seen in Australia and challenged successfully has been the attempts to do so effectively outside the reach of the law. It's what I call seeking to take the law out of the law, so that people are denied due process, denied access to lawyers, denied access to the law, to courts, unless they can get to lawyers who will assist in getting them to courts. And I think it's a really good example too, because of course, as we're watching this play out at the moment in the US, the judge actually ordered that planes be turned around, the people that were being deported, and that those that still hadn't left, that they're orders to prevent further action being taken to deport. In other words, to return to the status quo pending further argument about whether those deportations were lawful. And what we see here, and what's particularly dangerous, is a response from the Trump administration so far, which seems to deny that they are bound by the judge's decisions or orders. There's various arguments or purported arguments being made. All of that is to say, I think it's extremely dangerous, because not only in relation to the rights of those people deported and the conditions they're sent to, but also in relation to, I think, the most fundamental question, that is, and it's being described as a constitutional crisis. I don't think the question is anymore whether there is a constitutional crisis, how deep, how destructive it will be in essentially dismantling or decimating the separation of powers, and with that, the rule of law, whether the rule of law applies to questions about people's access to asylum, to detention, to fundamental rights. So I think it's very dangerous and very serious, and not new. It's just that we're seeing it play out with in a rule of law country, and what is being considered to be a leading constitutional democracy.
Thanks, David. I agree with you strongly. It is quite concerning. And as much as it's going to sound extremely hopeful of me, perhaps naively hopeful, but something that we are seeing when we speak to governments is that kind of conversation around the standard slipping. And they're like, well, if the US is doing it, why can't we? But I think something that we have tried to hold as just coming back to linking the strategic litigation developments in legal fora with advocacy, is that we're trying to encourage states also to set the standard now. And because the US has been considered a leading democracy, something that we are trying to encourage is that other states step up, and ASEAN states to set up, the APEC states to set up. That's
sorry to, can I just, one further point? No, I'll just put it very simply for now, but it'd be great to have a further discussion about this at some point. And I've been presenting for some years at the Strategic Litigation Roundtable UNHCR NGO one in Geneva on this question of externalisation. And the question also that I think we should, it's become even more acute and even sharper, the question of extraterritorial reach by courts. And so, in other words, put really simply, to what extent can we, essentially go to courts and get judges interested in enforcement when people have already been sent elsewhere to third countries? And that's a question, but I think there has been some really interesting litigation in Australia on this. In other words, even if someone is transferred, doesn't mean that responsibilities are transferred with that.
Thanks, David. Maybe we'll take just a couple more questions. It's great to see some of these questions come in, but I don't think we're going to be able to get to all of them. We will try to maybe follow up via email for the ones that we are not able to get to. Jenny had a question for you, David. What your view is on detainees not cooperating with the removal process. This is the current view in Hong Kong as it is in Australia. But in your view, does this violate the right to liberty in any way, and whether it can or should be challenged?
Yeah, well, I think that the one thing I should add to it is that the non-cooperation provisions that have been introduced as a response to the High Court litigation that I mentioned, also, this is for people with genuine fears that don't cooperate with their own removal. So if they're asked to, if they're directed to cooperate with their own removal, even where they have genuine fears of persecution, if they refuse, there is a mandatory minimum imprisonment now of 1 year and up to 5 years for refusal. So that clearly, in our view, violates various human rights obligations. I would say more generally that refusal to cooperate with removal, one of the fundamental questions in Australia is, has someone received a fair process in relation to their claims? So usually the questions arise when someone's been refused under the legal process and believes and is either seeking to have that decision reviewed, or there are new claims that they want to make that were never considered. Either they're new because of changed information or because they were never able to bring those matters. So there are multiple questions in relation to why someone would not be cooperating with their removal. And what we find in Australia is that in many cases, people are not able to raise those issues or receive reassessment of genuine fears. So, I mean, the crucible is really non-refoulement. That's are we looking at a situation where someone is being forced under threat of imprisonment, mandatory minimum sentence of 1 year imprisonment and up to 5 in Australia for refusal in that context to be deported to what potentially could be their own death sentence that they're being required to sign up to. And the final point I make is that on the question of, what about non-cooperation, removal and ongoing detention? Well, I think that the issue that I just raised before is relevant to this question too, and that is, should someone who is still pursuing their claims or seeking to have their case reopened continue to be detained? In our view, they shouldn't, in accordance with the ordinary principles of necessity, reasonableness and proportionality, etc. Yeah.
Thanks, David. I think I might stop there, just noting that we are 5 minutes over time and I don't want to keep people too long. We'll try to maybe answer some of these over email. And if you have any other burning questions, feel free to send them to Nandini, who can share her email in the chat. Not to put Nandini and her email on the spot. But okay, maybe just to kind of wrap up. Thanks, everyone. Thank you to all the panelists, Nandini, Sai, and David, for all your sharing. I think it's been even I've learned so much. And I talk about immigration detention day in, day out. So thank you so much for all those presentations. It was really interesting. I think it is a scary time in the world right now for immigration detention. It always is, but it is extra scary right now, especially with the challenges and changes at the US level. But hopefully what we've learned from all these different international frameworks is that there are avenues to challenge detention, and these kinds of strategic litigation initiatives and this collaboration with each other are more important than ever. So in the upcoming series, not to plug, but in the upcoming series that's happening in a couple more weeks, we will be talking a little bit more about why these collaborations are important and how to bridge that gap between strategic litigation and advocacy and make sure that we're all working together to really try to bring about some change. So if you haven't already signed up for the upcoming webinar in 2 weeks, that's going to be on monitoring detention and advocacy. I'm just dropping a link in the chat to register for that webinar. I'm getting into housekeeping now. So if you do need to drop off, that's all right. But we would also really appreciate, as we're continuing to organize these sessions, some feedback on how the session has gone. So I'm sending another link in the chat. If you could all fill out this feedback form, it shouldn't take too much time at all, just 5-10 minutes. Would love to hear what were the aspects that you enjoyed, what you didn't, and we can kind of incorporate these in the following sessions. I think that's all. And I do understand that maybe some of the participants here needed a certificate of participation to just allow you to take time out of your workday to spend with us. And if that is the case, please do email Nandini. I'll work on that feedback form access right now. Yes, it will.
I will do
Yeah,
that.
yeah, it's done. Thank you. You should be able to access it if you just refresh the page. Yes, and if you need a certificate, please do email Nandini. And that's all. Thank you, everyone. We'll catch you in the chat. And have a nice day.
Thank you, everyone. I see a question. If you can share questions separately via email, feel free to do that. My email is, I can send my email again, just in case.